Good afternoon, everyone, and welcome. Thank you for joining the Office of Court Administration for today's webinar, Deciphering Senate Bill 346, Understanding the New Criminal Court Cost Structure. My name is Neetu Gill, and I will be today's moderator. Prior to beginning, I would like to address a few housekeeping details. Please mute your microphone. If you have a question, please use the chat box. I'll be monitoring the chat box throughout the webinar. If you have a technical question such as you can't hear or you can't see, please let me know and I'll address that immediately. If there's a question pertaining to the topic, we will address those questions at the end of the webinar. We will also attach the PowerPoint and put this webinar on our website so you can view it later. Without further ado, I would like to introduce today's speakers, Mr. Davis Layton and Ms. Margie Johnson. Ms. Margie Johnson is an Assistant General Counsel in the Legal Division at OCA. She focuses primarily on all things related to court costs, felony judgments, expunctions, and non-disclosures in all aspects of criminal procedure and law. She has been with OCA for over 3 years. Prior to joining OCA, Margie practiced criminal law both as a prosecutor and criminal defense attorney for over 16 years. Mr. Davis Layton is the Administrative Director of OCA. He is also the Executive Director of the Texas Judicial Council. Welcome, David.
Thank you very much, Neetu. Welcome, everyone. Very glad you're able to join us today, thankful to be able to maybe begin to decipher a little bit about Senate Bill 346. Without delaying, we're going to go ahead and get started here. We'll talk about why Senate Bill 346 was passed and why was the change necessary. The first real reason for the change is the Salinas decision. Some of you may be familiar with it. This decision was issued in March of 2017 by the Texas Court of Criminal Appeals. And in that case, basically, there was a look at the consolidated criminal court cost structure and whether or not it was unconstitutional or not. And the court, you see an image of the first page of the opinion, the Court of Criminal Appeals found that the consolidated criminal court cost did have some constitutional issues and that it violated the separation of powers and the judiciary was acting like a tax collector because it was collecting court costs for items that were not related to a legitimate criminal justice purpose. And so it struck down 2 of the allocations from the criminal court cost and really if the legislature would not have corrected that, those allocations would not have been allowed to continue. The legislature chose during the 2017 legislative session to make those 2 corrections. But then coming out of that session, they began to look at the system as a whole, and they issued interim charges on both the House and the Senate side. And in those interim charges, both committees on both sides looked at what needed to be done to remedy any other constitutional issues that existed with the criminal court cost system, as well as trying to reduce the complexity of the system. As those of you who deal with the criminal court cost system on a regular basis will know, our structure has grown more and more complex over the years. There were, before this bill becomes effective, there are somewhere close to 150 separate criminal court costs. I always say that you have to pretend like you're doing a little bit of game of Twister to figure out which way to go, because sometimes things apply, sometimes don't. And so the goal of the legislative changes were to try to simplify the criminal court cost structure. The way that the legislature chose to do this is they asked OCA to work with them on identifying which court costs had potential constitutional issues, to try to reduce the complexity as much as possible, and to try to ensure that funds that were receiving amounts from the court cost or other fees or fines, that those funds would be made as close to whole as possible where possible. So whether it was at the state or the local level, that there not be a hit, so to speak, to the funding in those different funds. So that's really why the legislature passed this bill, Senate Bill 346. So let's jump into what exactly the bill does. There's really just a couple of really pretty basic things that it does overall. One is that it takes the existing criminal court cost system and consolidates all of those separate court costs down into 2 court costs for each level of court. So there are 2 at the JP level, 2 at the municipal court level, 2 at the district court level, and 2 at the county court level. Those two court costs are now the state consolidated criminal court cost and the local consolidated criminal court cost. And as you would assume, the state consolidated criminal court costs consist of funds that are to be directed to the state, and the local consolidated criminal court costs are court costs that are meant to be directed to the local government, whether that be the city or the county. And so those are now the only two criminal court costs that exist at each level of court. Once again, those are each level. And we'll talk a little bit more specifically about those in a minute, and some resources that will let you know exactly how much those are. But basically now, for instance, for every Class C misdemeanor, whether it be at a JP or municipal court, there is one state consolidated criminal court cost and one local consolidated criminal court cost, no matter what the offense is. Same thing at the district court level, no matter whether it's a first-degree felony or a state jail felony or somewhere in between, whether it's a DWI or a murder, the court cost amounts are the same for each of those offenses. Same thing at the county level courts and the JP level courts as well. So that's one big major change that obviously is intended to make that a little bit simpler to administer as far as the court cost goes. The second thing that the bill did was to redesignate the several of things that we previously considered as court costs, to redesignate them as fines or reimbursement fees. So when the legislature looked at this issue, they looked at all the various court costs that existed out there, and any of the court costs that were punitive in nature are now designated as fines. So they're no longer court costs, and you'll see that when we've attached as handouts to the webinar some of this, and we'll talk about them in a little bit detail in a little bit. There are many things that you will recognize that were previously court costs, which are now actually fines because they are intended to be punitive in nature. So an example I keep giving folks is the passing a school bus in the municipal and JP courts. I believe it's in the municipal courts. That used to be considered a court cost that would be assessed whenever someone passed a school bus in one of those cases. Obviously, that cost doesn't cost any more to process this passing a school bus case, so it's not really recouping the cost of the court. It's more of a punitive nature, which the intention is to punish the offender for passing a school bus. So costs like that have been redesignated as fines, and you will see that as we go throughout, that there are several that have been treated that way. The third option of different costs now are that many of the court costs that used to exist out there are actually for recovering the cost of services that were provided during the course of the case. So these are now known in the law as reimbursement fees. So many things used to be called a court cost. It's now actually designated as a reimbursement fee. This is important. There are some Court of Appeals opinions and even a case pending at the Court of Criminal Appeals right now, which deals with whether or not a reimbursement fee, what will now be known as a reimbursement fee, is allowable as a criminal court cost. And so the intent there is to try to correct that issue as well. So there'll be a list of those as well. The legislation did not change whether or not various fines, reimbursement fees, or even the court costs themselves, whether they are mandatory or optional. If the law previously said the court shall assess this amount, or the court may assess this amount, there was really no change made with that. So that's the key with regard to that. One thing I want to clarify with the consolidated court cost, I want to make sure I don't misspeak here, that there's really no change with regard to when the state consolidated criminal court cost is to be applied. And in particular, with violations of municipal ordinances related to pedestrian or parking of a motor vehicle, there again is no change. So the state consolidated criminal court cost still does not apply to those parking and pedestrian cases that are a violation of municipal ordinance. So just be aware that really the underpinnings of this didn't really change with regard to whether things were mandatory or optional. The last thing that the Senate Bill 346 did was to attempt to redirect all of the various funds being generated from these court cost fines or reimbursement fees to legitimate criminal justice purposes. In particular, the criminal court costs and the reimbursement fees, that when they are being collected, there's no ability to challenge that the courts are again being used as tax collectors, but instead that the funds that are being generated are actually being used to either cover the cost of processing the case in the courts, or to reimburse for costs that have been incurred as part of the case. The exception, of course, are fines, and we'll talk a little bit about this more as we go throughout the webinar. But fines, of course, have traditionally, as punishment, been able to be used for whatever purposes the legislature chooses. They don't have to be used for recovering costs, and so that is somewhat of an exception to that. So that's the basics of the Senate Bill 346. Let's talk a little bit about the effective date. And for those of you that are from county and district courts, I would ask you to maybe tune out for a second, because this might be a little bit confusing. This next slide really deals specifically with JPO municipal courts. There will be one in a second where I'll ask the JPO municipal court folks to tune out, because the law is different when it comes to the way the effective date is treated in JPO municipal courts versus those in county and district courts. So to try to illustrate this, we've provided for you a couple of examples so we can talk through how this works. So you'll see, just to explain what you're seeing here, obviously, you'll see the effective date of 9/1/19, and there'll be an example where that will be really important, and then the effective date of January 1st, 2020, which is the effective date of the act. So the key here is that in JP and municipal courts, the changeover from the old law to the new law becomes effective on January 1st of 2020. If you look at Senate Bill 346, the very end of the bill, it says that the changes in the law apply to offenses which occur on or after the effective date of the act, which is January 1st of 2020. So it's offense date in JP municipal courts that's important. The one thing that's interesting in this is that there was also a bill, which we'll talk about in a second, that changed the amount of the state traffic fine, and that bill went into effect on September 1st of 2019. So you'll see as I go throughout this, that's important. The only other thing I would say that's important to keep in mind is that fines as punishment can't really change after the offense date because of a constitutional provision of ex post facto, meaning you can't change the punishment after the fact. And so when we're talking about fines, there's going to be a little bit of a distinction between that and court costs and reimbursement fees. So with that in mind, we'll start with an example here. The top little line you'll see shows that the offense date, which is going to be reflected by the arrow, the offense date was before September 1st of 2019, but the conviction date, or the circle in the graphic, is between September 1st of 19 and January 1st, 2020. So offense date before September 1st of 19, conviction date before January 1st of 2020. In this instance, you're going to use both the old court costs, or the ones as they exist today, and the old fines, including the state traffic fine that was in effect prior to September 1st of 2019. So old court costs, old fines. The second example you'll see shows that the offense date in this instance occurred after September 1st of 19, and the conviction date occurred before January 1st, 2020. In this instance, of course, the offense date is after the September 1st, 2019 effective date of the new state traffic fine, but it's also before the changes in the court cost pursuant to Senate Bill 346. And so in this instance, if that was the case, you would use the old court cost, or the court costs as they exist today, but you would apply the new state traffic fine because that went into effect on September 1st of 2019. The third example shows that the offense date occurred before September 1st of 19, and the conviction date is after January 1st, 2020. Once again, the key for JP and municipal courts is when is the offense date, and the offense date in this example is before September 1st of 19 and before January 1st, 2020. Doesn't matter when the conviction date occurred, you will still use the court costs and fines that were in effect on the offense date. And so in that example, you will use both the old court cost and the old fines. The last example is an offense that occurs after January 1st of 2020, and the conviction date, of course, occurs after that. In this instance, once again, the offense date is key here. The offense date occurred after January 1st, 2020, and so you would use the new court cost and all of the new fines that are in place, both this new state traffic fine and all the other fines that apply in those instances. So if you're in a JP municipal court, or you are handling a case that is covered by one of those courts, the key is to look at when is the offense date and what was the law, both court cost and fines, that were in effect on the date of the offense, and that's the key thing there. So those of you that are in JP municipal courts, you can maybe tune away for a second here, and those of you in county district courts will want to listen up, because there's a major distinction between those levels of courts when it comes to the effective date, and we'll talk about that here. I'll point you first to the bottom of the screen here. For those of you that are dealing in county district courts, there's a specific provision of law, Government Code Section 51.608. I've just excerpted a little bit of this. I didn't put the whole statute just for space, but basically it says that notwithstanding any other law that establishes the amount of a court cost collected by the clerk of a district, county, or statutory county court, the amount of a court cost imposed is the amount established under the law in effect on the date the defendant is convicted of the offense. So whereas JP municipal courts really key back to the offense date, in district and county courts, you're going to key primarily for court cost purposes, you're going to key to the date the defendant is convicted. So that is a major distinction, and you'll see that play out in the examples here as we go throughout this. So the one other thing I should point out is that only applies to court cost. That law does not apply to fines or reimbursement fees. So it's going to get a little tricky when it comes to an offense date that occurred before January 1st of 20 in the county district courts. But with regard to court cost, you need to look at the conviction date. So let's look at a couple of examples here to see how it applies in the county district courts. So again, the first example, similar. The offense date occurs prior to September 1st of 19. The conviction date occurs before January 1st, 2020. So again, what's the conviction date and what's the offense date? So the conviction date is before January 1st of 2020, so it's before the change in law with regard to court costs, so you would use the old court cost. And the offense date is before September 1st of 19, so you would use the old fines as well. So hopefully that makes sense. The second example, the offense date occurs after September 1st of 2019, so when the new state traffic fine is in effect, and before the new changes in law with regard to court costs go into effect. So in that instance, you will look at you'll still use the old court cost because the conviction date is before the new law goes into effect, but the new state traffic fine is in place on the offense date, so you will use the new state traffic fine. The third example, the offense date occurs before September 1st of 19, and the conviction date occurs after January 1st, 2020. In this example, the conviction date is after January 1st, 2020, so you will use the new court cost because 51608 says it's the date, the court costs that are in effect on the date of the conviction. But because the offense occurred before September 1st of 19, you will use the old fines in that example. So you would use what the new fines that exist under Senate Bill 346 would not apply. You'd be using the fines that were in effect on the date of the offense. The last example is the easiest one when things will get become more simpler, which is that the offense date and the conviction date occur after January 1st, 2020. And of course, because the conviction date is after the effective date of the new court cost, you would use the new court cost, and the offense date is after January 1st of 20, so you would use the new fine structure as well. So just to sort of try to summarize this for those of you in JPU municipal courts, everything keys off the offense date, what was in effect on the date of the offense. For those of you in county district courts, the court costs are going to key off of the conviction date when that occurs and what's in effect on that day, and the fines are going to look at what was in effect on the date of the offense. So a little bit complicated when it comes to dealing with the fines in the county and district courts just because of that issue. Hopefully that makes sense. We'll have some time for some questions at the end. I'm sure there may be a few about that, but we will move on to the next slide to talk about the distribution of the court cost fines and reimbursement fees. And I know some of you have reached out to me about this, so hopefully we'll try to be able to explain this as easily as possible. And the handouts that are attached and will be put on our website will hopefully provide a little more guidance with this as well. So we'll start with court costs and how do we distribute the court costs that come in. So the local government code sections, I guess actually chapters 133 and 134 lay out how the court costs are supposed to be distributed. So 133 deals with the state consolidated court cost, and 134 deals with the local consolidated court cost. And if you're taking notes, the specific sections for the state consolidated court cost are 133.102A3, and the local consolidated court cost is 134.103A. And so those specifically lay out what percentage of the court costs that come into the coffers are to be put into what funds. So because most of you are probably local government officials on this webinar, I'm going to speak specifically to the local government ones, the local consolidated court cost. Of course, the state, when they receive the state consolidated court costs, will do the distribution. So the state comptroller does that and have been doing that for many years. They will continue to do that. Those of you who are interested in money that's coming to the state, you will see that the allocations to the various funds did change in Senate Bill 346. But if you look at the fiscal note, for instance, the anticipation is that no funds lose any money from what they were receiving before, unless there was a specific decision by the legislature to change that, which was not really, did not occur very much. So with regard to the local consolidated court cost, I'm just going to take for an example here the municipal court consolidated court cost. So the local consolidated court costs for the municipal courts in Class C offenses is $14. That's how much is coming in from that. And all of that money, 100% stays with the city and is deposited in the city treasury. So when the money comes in from the local consolidated court cost, the statute specifically in 134.103A lays out that the 35% of the money that comes in should go to the municipal court building security fund. 35.7143% goes to the local truancy prevention and diversion fund. 28.5714% goes into the municipal court technology fund, and 0.7143% goes into the municipal jury fund. So if you didn't catch those percentages, they're in the statute, and you'll see it in the materials we provide to you at the end of this presentation. But that's how the money gets split. So if $100 comes in municipal court costs to the local consolidated court costs, that's how it's split up by those percentages. Of course, the funds that those go into are also, many of them, if they weren't already in existence in the statute, Senate Bill 346 establishes those funds. Even at the local level, and then designates what's exactly how that money can be used. And again, our materials that we'll give you at the end really do lay out what that is. I should point out that I think the statutes reference I gave you were just for the municipal courts, so the local consolidated court costs. So we'll come back to that at the end where I can give you those, but they're all in chapter 134 of the local government code. So with regard to fines, so that's sort of the way the court cost works. And the way that that happens is that the auditor or treasurer, however it's done in your county or city, will allocate those local consolidated court costs to those funds, and that's how the money will be split up. With regard to the fines, basically, you might recall that in the past there was pretty much only a general fine. So if you were at a district or county, a district court, you know, a fine up to $10,000 was able to be levied against a defendant in certain cases. In a county court, maybe a fine of $2,000 or $4,000. In a JP municipal court, maybe a fine of up to $500. So in those instances, in the past, that was the only fine that existed. maybe the state traffic fine, but for the most part, those were the general fines that were there. And all of that money stayed with the city or county and could be expended however the city or county wanted to spend that money. The key now is that there are multiple fines, those court costs that have been designated as fines. The statutes will generally lay out what the fine, how it can be used. It may just be able to go to the general fund of the county or the city or the state, or it may be for a specific purpose. And so when you're looking at fines that will be assessed in various cases, you're going to want to look to see what is the fine allowed to be, where's it supposed to go, and what's it allowed to be spent on. So we'll talk through some of those again as we get towards the end of the presentation, but that's a key difference. Of course, some of these fines are specific by offense, some of them are sort of the general fines, so that's a key to kind of keep in mind as you look at that. Pretty much the same thing applies on reimbursement fees. Reimbursement fees, as I mentioned earlier, are used to reimburse the city or the county or a third party for a service that has been provided in a case, and the statute will indicate where the funds go. You can pretty much guess that these reimbursement fees are going to go to the place where the money was spent to provide the service. So an example of this is the peace officer fee. So when a peace officer goes out and serves a warrant, for instance, what used to be the peace officer court cost is now a peace officer reimbursement fee. So the county or the city has expended funds to have the peace officer go out and serve that warrant. Now that when the reimbursement fees come in, they go back into the county or city treasury to reimburse the county or city for the services of that peace officer. So that's really the key to remember there is the reimbursement fees once again, the statute will indicate where they're supposed to go, but you can pretty much count on the fact that it will go wherever the funds were expended from to begin with. Let's talk a second about the state traffic fine, because this is you got to think about this when you're looking at Senate Bill 346, because it's the other major change with regard to court costs or fines, and it was House Bill 2048. It increased the state traffic fine amount from $30 to $50. And this bill became effective for offenses committed on or after September 1st of 2019. Some of you may be familiar with the provision in statute that says that basically makes changes in court costs become effective on January 1st. Obviously, this is a fine, so that doesn't apply because this is not a court cost. So it did go into effect on September 1st of 19. So for all offenses that occurred on or after September 1st of 19, no matter what level of court they're in, the state traffic fine is now $50, increased from $30. Now, nothing really changes about when this fine is assessed, but just as a reminder, it's only assessed when the defendant's convicted of a rules of the road offense under chapters 541 to 600 of the Transportation Code. So there's specific offenses. It's the same as when you used to assess the state traffic fine. You do the same thing here, except it's now $50. Just to be clear, and we'll talk about this a little more in a second, but conviction in this instance does include deferred adjudication and deferred disposition. So even if they're getting deferred, you still would assess that as well. The other key change here is that in the past, the county and city used to be able to retain 4% of the amount of this, 5% of this amount, and they would send the other 95% to the state. That has been changed to 4% being retained by the county or city as a collection fee, and 96% of that going to the state. I should point out that on the state consolidated court cost, nothing has changed with regard to the county or city's ability to retain 10% of that consolidated court cost as a collection fee. So as far as you used to send 90% of that to the state, you still send 90% of that to the state. Nothing changed with regard to that, even though the dollar amounts are perhaps more or different at that point. So, but the state traffic fine, it's only 4% is able to be retained by the county or city. So just keep that in mind as you think about the state traffic fine. Okay, let's talk for a second about what's a conviction, because this is a really important distinction when it comes to looking at court costs, fines, and reimbursement fees. So the general definition of conviction in statute does not include deferred adjudication and deferred disposition. Those are not considered convictions for most purposes, because obviously at the end of that, if someone successfully completes, they're not considered to have been adjudicated of that crime. So the key here is to to think about that when you're looking at statutes which say this court costs, fine, or reimbursement fees shall be assessed upon conviction. So even though the general definition doesn't include that, there are specific court costs, fines, or reimbursement fees that the statute alters the general definition of conviction. So, and we will point this out to you in the materials we're providing to you, but for the most part, unless a statute specifically defines conviction to include deferred adjudication or deferred disposition, the conviction does not include that. So it's got to be specifically referenced in the statute, and that's a key thing as you look at assessing these. Now, one general exception to that is any court costs, fines, or reimbursement fees that are in the local government code. There is a definition that's a broad definition of conviction that does include deferred adjudication and deferred disposition. So if the underlying statute for the court costs, fines, or reimbursement fees is in the local government code, when it says convicted, it's going to include deferred adjudication and deferred disposition. But if it's not in that, then you need to look at the specific statute. When court costs, the primary place that other court costs, fines, and reimbursement fees are in the Code of Criminal Procedure, unless the statute the specific statute on that court cost, fine, or reimbursement fee include a different definition, the Code of Criminal Procedure does not have a conviction definition that includes deferred adjudication and deferred disposition that fits all of those. So that becomes a little bit confusing when you're looking at when it says defendant who's convicted shall be charged this amount. You really need to look and see if it's not in the local government code, is there a definition in the statute that includes deferred adjudication, deferred disposition? Or you can look at our cheat sheet that we'll be showing to you here at the end, or talking about at the end, where we actually say whether it does or does not include deferred adjudication, deferred disposition. One key change that we wanted to point out to you is the time payment reimbursement fee, previously known as the time payment fee. Many of you may know this was a fee that's allowed to be charged in a case when a defendant does not pay all of the court costs, fines, reimbursement fees within 30 days. If they get on a payment plan, for instance, then the jurisdiction was allowed previously to assess a fee of $30 in the case. That fee was changed. It was reduced from an amount down to, I believe, $15 in a case. And the statute was moved from the local government code to the Code of Criminal Procedure. So if you'll remember what I just said a minute ago, court costs, fines, and fees that are in the local government code, the definition includes deferred adjudication, deferred disposition. That is not the case in the Code of Criminal Procedure. So when it was moved from the local government code to the Code of Criminal Procedure, they changed really the definition of conviction to no longer include deferred adjudication and deferred disposition. And there was no specific definition for conviction included when it was moved. And so the time payment fee can no longer be charged for deferred adjudication and deferred disposition, only when a defendant is actually convicted. So that's a pretty significant change from current law that we wanted to make sure that we pointed out to you. But when you get down to it, once again, you're going to want to look at if you want to look in the background, you want to look at the existing statute to see what it says with regard to what's the definition of conviction. And the key is if it's in the local government code, it includes deferreds. If it's not, you're going to want to look specifically to the statute, or you're going to want to look at our specific handout to assist you with that process. One other thing that we wanted to talk to you about is, so how do things change with imposing the court costs, fines, and reimbursement fees? And there's been several cases over the years and even some law changes over the years dealing with how this process works. So we'll break this down once again in the three different categories. So with regard to court cost, generally the way that has worked, and this doesn't really change here, is that you're going to want to include the total amount in the judgment of the case. And the law is clear that those court costs don't become payable until a bill of cost is produced if you're in a district or county court, or if you're in a JP or municipal court when the bill of cost is produced or ready to be produced. There's a distinction in the law between those. And so, in other words, the defendant's not liable to pay those in a district or county court until they actually get a bill of cost which detail out what the various court costs are. And you'll see below, the same thing applies to the reimbursement fees is that we believe those should be detailed in the bill of cost too, so it's clear as to what they're paying. In the JP Municipal Courts, that bill of cost is not required to be produced before the defendant's liable to begin to paying those, but it has to be ready to produce so that if, say, a defendant asks for it, the JP Municipal Court can provide that to them. With regard to fines, since these are a part of punishment, we believe that they should be pronounced at sentencing, so a judge should actually indicate which fines are being assessed against a defendant at sentencing, specific and as part of that, and that those fines should be made a part of the judgment so that the defendant knows exactly what he or she is being fined for. We are working, and Margie's going to talk in a few minutes about this, but we are working on adding to the felony judgment forms that OCA is required to promulgate a listing of all the fines so that a judge could easily add that to the felony judgment so that it would be available to the defendant at the time of the judgment. But once again, it should be pronounced at the sentencing and made part of the judgment if it's a fine. The last is obviously reimbursement fees. As I mentioned a second ago, we believe that the total amount should be in the judgment. Most of you probably don't even have a place for reimbursement fees right now because those haven't existed before, but we believe on January 1st of 20, you should make sure that your judgments include a place for reimbursement fees. There should be a total amount in there, and that the bill of cost should include a section on reimbursement fees, which ones have been assessed in the case, so that the defendant can be made aware of those costs. The last thing I wanted to talk to you about is, so what does all this mean in light of Senate Bill 1913 from last session? Some of you might recall this is the law that dealt with trying to look into the defendant's ability to pay court costs, fines, and fees. So you're going to see on in several of the laws and even on our handouts, several places where we say that certain court costs, fines, and fees are mandatory, or certain court costs, fees, and fines are optional. I'll remind you that nothing in the law changed with regard to whether those things are mandatory or optional. The law still says shall or may, just like it always did. So really, the bottom line is nothing has changed with regard to a judge's obligation to look at ability to pay and establish a court cost, fine, and fee, reimbursement or payment as appropriate, depending on the defendant's ability to pay. So just as a reminder for everyone about what Senate Bill 1913 did, and this is significantly simplifying this, but just to give you the high level, last session the law was amended to require judges to consider ability to pay at sentencing. So when a judge is considering sentencing and therefore looking at the court costs, fines, and reimbursement fees, they should inquire about a defendant's ability to pay. And so that still is applicable under Senate Bill 346, just like it is today. In fact, there were several amendments to Senate Bill 346 through the process, which actually reinforced last session's changes to be able to give a little bit more detail into what is the judge's obligation to consider ability to pay. But it's basically the same as it was before. The judge is required to look at their ability to pay and also consider whether or not it makes sense to put them on a payment plan or discharge it through community service or some other type of method. The one thing that's really important here is that nothing also changed about Senate Bill 1913's provision, which gives judges pretty broad authority to reduce or waive court costs, fines, or reimbursement fees. Even if they are listed in statute as the judge shall assess them, the law is clear, and then it allows judges to then consider with ability to pay reducing or waiving those. It would be our recommendation that those mandatory court costs, fines, and reimbursements should actually be assessed, and then the judge should consider reducing or waiving those as part of the process. So maybe you assess the fine, but then you consider the defendant's ability to pay, and then you waive it or you reduce it. So judges can still tailor the court costs, fines, and reimbursement fees as appropriate to meet the needs of the defendant as part of the process. I'm going to turn it over to Margie, who's worked significantly on trying to simplify this into a couple of resources for you, and she's going to talk you through those. Several of them are provided for you as handouts in the webinar materials, and we can talk about those, but I'm going to turn it over to Margie for that purpose.
Are you able to put those up?
Oh, sure.
So as far as the available resources, we put together 2 different court cost charts for each court. So for each court, you will have 2. One chart, we'll refer to as the training chart. It lists all the requirements and conditions that must be met before you can assess a particular cost, fine, or fee. I think that chart might be most helpful to you. But also, since you're familiar with how we normally do our court cost charts, we thought it was also important to give you another court cost chart that sets out the fines, fees, and costs for specific offenses. I stuck with the same offenses that are currently on the court cost chart, and I think that will work out nicely for you. I believe you should be able to upload those from the webinar. If not, we will put those on our website immediately following the webinar. The other thing that's coming to help you is updates to the felony judgment forms, and we will be changing the felony judgment forms, the first page where you currently report the fines, the restitution, and court costs, because that will need to include fines, and the fines unfortunately will have to be detailed. So we're going to take recommendations on that. Currently, we're considering having courts use a checklist. Now, I know that there is a bill of costs that courts have to produce, but we're afraid that that bill of costs just will not be detailed enough for these particular fines and reimbursement fees. But we're open to suggestions, so if you have any suggestions, please send me an email. You'll see my email address at the end of the webinar, the last page on the PowerPoint presentation, and it's also on the court cost charts as well.
Great. Thank you, David and Margie. I really appreciate y'all coming out here to talk on this topic. So we now are going to open the floor to questions. Before I get to the questions, I just want to let our audience know that, like I mentioned before, we will post the PowerPoint and the recorded webinar on our website. All you have to do is go to our website and go to publication trainings, and there'll be a drop down to webinar. We'll try to get this posted as early as next week. You guys ready for some questions?
Sure.
Okay, perfect. Let's see. Okay, so one of the questions is, okay, muni courts have some repealed fees. Example, muni jury fees or local truancy funds. So where will these new fines be designated? Will be designated to go?
Yeah, so that's a one of the things. So a lot of the repealers, and you'll see this on the handouts because Margie included all the repealed fees, fines, court costs as they applied to each level of court. A lot of those repealers were because those amounts were consolidated into the consolidated court costs. So the example of the jury fee and the truancy fee, both of those are now a part of the consolidated court costs. And as I mentioned earlier, those get an allocation from the court costs. So if you actually did the math and you take the $14 and multiply it by the percentages that are in the distribution, you'll see those amounts look very familiar because they're the amounts that were previously assessed for the local truancy fund or whatever. So the intent is that at the end of the day, the jurisdictions will be receiving the same amount of money. It's just done through a single consolidated court cost and then distributed to those funds versus the 4, 5, or 50 separate criminal court costs as they existed before.
Great. Another one of our attendees is asking, so David, you use the word fine to apply to both the penalty for having, sorry, let me just scroll down. Sorry, you use the word fine to apply to both the penalty for having committed the offense and those fines formerly known as costs, which are now classified as fines. How would one tell the difference?
Yeah, so there's now, the basic bottom line is there are now multiple fines for certain offenses. So the way we're referring to it, and you'll see it on our chart, is there's the general fine. It's the fine that we've always called a fine before this bill passed. So it's the up to $10,000 on a felony or up to $500 on a traffic case or whatever. So those are what we're calling the general fine. But now for certain offenses, there are other fines, like the state traffic fine, for instance, that is only applicable in certain cases. So there are multiple fines now for many offenses. Not every offense has multiple fines, but many of them do. And you'll see on our charts here, and you know, like Margie said, you've got the one with the columns on it that show the various types of offenses. We try to make it to where you can pretty much go down the column and see when does a fine apply, when is it mandatory, when is it optional. And you know, so obviously if it's a mandatory fine, it has to be assessed. Doesn't mean the judge can't waive it or reduce it at the end of the day. But there are now in effect multiple fines per case.
Which is why you'll have to specify them on the judgment.
Right. You can't just say $10,483 as your fine, because what is that made up of? It's the reason why the judgment really has to include all those separate fines that have been assessed against the defendant.
Right. David, I'm going to scroll back. We have a couple of questions pertaining to the diagram that you had. So is the question is, so is the arrow the offense date and the circle is the conviction date?
That's correct. So on both the JP and municipal court and district and county, we've tried to represent the offense date by the arrow, at the end of the arrow, and the circle is the conviction date. So once again, just to try to make this as simple as it possibly can be, and I understand it's not really simple, is in JP and municipal court, everything depends on the offense date. What was in effect on the date of the offense? It doesn't matter when the conviction occurred. If the conviction happens 5 years from now, it doesn't matter. What was the offense date, and what were the court costs and fines that were in effect on the date of the offense? So that's pretty straightforward. Probably the more complex one, if you can switch to the next screen, Nitu, is the district and county, which is district and county for purposes of court cost only. You look at the conviction date. What was the date of the conviction, and what was in effect on that date? For purposes of fines and reimbursement fees, you look at what was in effect on the on the offense date. So those of you that are probably thinking, well, there weren't reimbursement fees before January 1st of 20, which is true. So if the offense occurs before January 1st of 20, there are no reimbursement fees. There were no other fines before January 1st of 20. So it's only the general fine that applies before January 1st of 20, besides the state traffic fine, I should be clear. But in district and county, it's a little bit more complicated because you have to look at the court costs based upon conviction date and fines and reimbursement fees based upon offense date.
Great. David, we do have another question. It's also pertaining to this slide. I believe you touched on it, but I'm just going to go over it again. So the attendee is asking, so the offense prior to January 1st, but Omni or TPF assessed after January 1st, would it still be the old amounts as well? They continue to say, I believe that's a plain reading of the bill, but I know DPS has existing agreements with cities regarding Omni.
Yeah, so I believe I think you're talking about the Omni fee, which is now it's referred to as the administrative fee, and that is a mandatory reimbursement fee. So you're going to look at what was in effect on the date of the offense. So if most of the time, I'm assuming this may be a JP or municipal court requester. So on a JP or municipal court, you're going to look at the offense date. What was in effect on the offense date? So the Omni fee that was in effect on the offense date is what you're going to charge on that offense date. So right now, the Omni fee is $30. You're going to be assessing it based upon what was in effect on the offense date. So it will stay $30. If the offense occurs after January 1st of 2020 in a JP municipal court, it's now $10, and it's and all the money stays local. So you've got to you're going to have to sort of operate in a couple of worlds here for probably several months, maybe several years, depending on how old your cases are. And then at some point we'll make the transition fully over. But on JP municipal courts, it's offense dates. On district county, it's conviction date for court costs, but offense date for everything else.
Okay, perfect. Another question is, if a defendant is allowed to pay the driving safety fee over more than 30 days, does it get the time payment fee?
So basically, the way that the law reads is that so the time payment fee. I'm going to assume this is under the new law, which I think is also the same as the current law, but we'll just presume it's under the new law because the statutes now in the Code of Criminal Procedure, Article 102.030 says that you assess that time payment reimbursement fee if the convicted defendant pays all or part of a fine, court cost, restitution, or other reimbursement fee on or after the 31st day after the judgment is entered assessing the cost. So no matter what it is, if they pay some cost or fee after the 31st day, on or after the 31st day, then the time payment fee is applicable. That is a mandatory reimbursement fee, which means it's mandatory to be assessed, but once again, the judge could choose to waive or reduce that if they wanted to do so. And all that money, if it was after January 1st of 2020, that amount is $15, and all that money stays local because there's no money to go to the state from that under the new law. And Margie has something to add to that.
And so I'm wondering if what this particular person may be alluding to is whether or not conviction is going to impact it at this point. I believe the question was if the person.
Yeah, let me scroll back up to that again. If a defendant is allowed to pay the driving safety fee over more than 30 days, does it get the time payment fee?
I would think once this bill goes into effect that it would not, because with the driving safety, there has not been a conviction. That is
after conviction,
right? And so now the time payment fee after January 1 will no longer include deferred adjudication or deferred dispositions. You will need a conviction in the traditional sense.
That's a good point. Thank you for making that.
This is a detailed question. I'm not sure if you guys recall this. So someone's asking, so the court costs are going from $99.10 to what was it again? I know that's a detail. And then the $66 court cost is going to $76.
So we can tell you really quickly what the court costs are going to be. At a JP and municipal court, the actual court costs are going to be $76. So that's the actual court cost. The state consolidated court cost is $62 and the local consolidated court cost is $14. Again, I'll say that it doesn't apply to parking and pedestrian and municipal ordinances, but with all other cases, it's $62 and $14. At the county court level, the state consolidated court cost will be $147 and the local consolidated court cost will be $123. So that's a total of $270 is what the court cost is for any class A or B misdemeanor where there's a conviction. And then at the felony level, the district court or felony level court cost, the state consolidated court cost is $185 and the local consolidated court cost is $105. So the total is $290 when you add those two together. So that's basically how the court costs work out. Then a judge would have to consider whether or not there were any fines that were applicable or any reimbursement fees that were applicable that the judge wanted to assess. And then they could, once they have all those added together, they can determine whether or not they want to reduce or waive any of those that were applicable in that case.
And so if you look on the court cost chart that has the totals for specific offenses, I believe that's maybe what this particular person may be talking about. So you're correct. With municipal court, the total amount owed can be as low as $14 or as high as maybe $179, really depending on the offense and whether or not reimbursement fees apply or if the judge waives or reduces any of these fees. And yes, you are correct. When it comes to the district court, you are looking probably at a minimum of $290 going up to $390 just as minimum cost, because then you have on top of that whatever general fine the judge is going to impose, as well as services that are performed, which will add on reimbursement fees.
And I want to be clear in case anyone's confused. I want to make sure I make this clear. The legislature did not increase the overall total cost on defendants. They just sort of shifted things around. So if you go back and look, and we've certainly got charts we could show this to you if you want some more detail, but if you went up and added all the various separate court costs that were in effect for the various offenses, these were the amounts. It's just now they're consolidated down into one amount versus being multiple court costs as they were before.
And this does go effective on January 1st of 2020, correct?
Yes, that's the law becomes, Senate Bill 346 becomes effective on January 1st of 2020.
Okay, let me see if there's any, let's see. There's another question. You guys have a few more minutes.
Sure.
Question about costs that were changed to fines. Will we need to change the way we apply partial payments or installments based on the cost first rule?
So that's an interesting question. I'm glad you asked. Nothing changes with regard to the cost first rule, which means you're still going to look at applying things to the state court cost and the overall court cost first, and then to reimbursement fees and fines. So nothing has changed with that. You will still do it that way. It's just now the amounts are different that you're applying it to.
Yeah, a fine is a fine. So whether it's a general fine or one of the more specific fines that are listed on this chart, they should be treated the same.
Okay. We have some more questions. If a municipal court does not have a juvenile case manager, what does the city do with the $5 local truancy prevention and diversion fund?
You put it into the local truancy prevention and diversion fund until you have a juvenile case manager. The law basically says that money can be used to pay for the salary of a juvenile case manager. And then if all the expenses of the juvenile case manager's salary have been covered, can be used for other purposes of prevention and diversion. But it sort of presupposes that the jurisdiction has a juvenile case manager. One of the things that's, I think this is meant to address is many jurisdictions have said we'd really like to have a juvenile case manager, but you couldn't start keeping the money until after you had a juvenile case manager in place. And so, this allows you to start building that fund in case you want to have a juvenile case manager in place. But that money cannot be used for any other purpose other than basically sitting there.
We have over 50 more.
So it looks like we have a lot of questions. Maybe we can answer a few more, need to, but the other thing I would say is we will get the list of these questions and we'll put answers down and post it. So that way, and the other thing too is obviously, we've got the slide at the end here that if someone has questions, they can reach out to Margie separately.
So let me pull up Margie's contact information again. And so at the end of this webinar, when you close out, you'll get an evaluation. I encourage you to please fill out that evaluation. It just helps us with our webinars and the topics we present on it. On the evaluation, you'll have a section to ask additional questions. Please use that box to type in your questions, and I will get that to Margie to make sure that they're answered. And I'm really sorry if we didn't get to your question on the chat box. There's just so many coming in. I'll relay those to either David or Margie, and they will reach out to you individually and get those answered.
Yeah, we'll probably try to take do like a maybe not a frequently asked question, but at least a once asked questions, and put those out there and attach it with the webinar.
Perfect. Oh, yeah, that would be good. But also, you have my contact information. Please don't hesitate to call or email me. If you don't hear from me the same day, I will get to you as soon as I can within a day or two.
Great. Once again, thank you, David and Margie. I really appreciate you guys joining us today. And thank you, everyone, for attending.
Thank you.